Welcome along. Redundancies are a reality for many employers, but managing them fairly and lawfully can be difficult, especially when you're only letting go of one or two people. I'm joined today by Nick Hobden, partner and head of the employment team at Thompson Sand & Passmore, to talk about what employers need to get right in small-scale redundancy situations. Nick, redundancy is quite a loaded term, but what does redundancy actually mean in law?
Well, redundancy means several things, but the starting place is always the Employment Rights Act 1996, and specifically we're dealing with section 139 here, because what that says is that, assuming that redundancy is one of the fair statutory reasons for dismissal, which it is, then redundancy can take the form of business closure or workplace closure, or that the requirements of the business to employ employees to carry out work of a certain kind are going to cease altogether or diminish to the point where, for example, they are no longer required to be full-time employees in that role. And it's important that employers establish the reasons for the redundancy falling within one of those provisions, because often employees make the mistake of using redundancy to cover performance issues or capability issues. And that's really not what redundancy is all about.
Thank you, Nick. So once an employer decides that a redundancy situation exists, how does an employer go about deciding who's affected by it?
Well, the next position for the employer to examine is who potentially they need to make redundant. So the numbers of employees, is it going to be a head count reduction? And then they have to establish a fair pool for selection for redundancy according to those employees who carry out similar work or who have similar jobs. And what they're expected to do, what the employment tribunal expects them to do, is to examine across their whole workforce employees who conduct similar roles. It's very easy for an employer to say, oh, well, this person is in a pool of selection of one, and leave it at that. But the potential is that they may trip themselves up because someone else who was doing similar work should also have been included in that selection pool for selection, and they ignored that person. So the essence is that they have to justify their selection pool, even if it is a selection pool of only one. And if they do that and they carry out that exercise and minute it or note it down, then that's pretty good evidence if it comes to an employment tribunal claim later.
So we've got our pool of people affected. So from within that pool, how does an employer then select who's going to be made redundant?
So an employer has to agree amongst itself, under its management team, a fair selection criteria. There has to be objective and measurable criteria. So, for example, one would include performance, skills, experience, perhaps attendance record, disciplinary record, and decide on a weighting amongst those fair elements to decide which assumes primacy. What it shouldn't really do is to hit on the most expensive employee and single them out for redundancy, because that will tend to attract criticism from the employment tribunal on grounds of fairness or unfairness of selection criteria. It's okay to include the salary costs in amongst the criteria, but it's always helpful to balance that with other specifically measurable criteria and use the criteria in a way that can be non-discriminatory. So, for example, exclude age from the criteria, exclude sex from the criteria, exclude fitness from the criteria, unless the demands of the role require that someone has to be medically and physically fit. And when they apply that criteria, they have to do it in an evidence-based way. So they have to know the individual concerned and know what their skills, experience, and performance is like, in order that they can make a judgment on where they fall in terms of the selection criteria, either meeting requirements or below requirements. That's what they have to do. They should always share that criteria with the potential candidates for selection and consult with them on that criteria, because who knows, one of those employees may say, well, I think you're applying the wrong criteria and you should include this, for example. So that's what they've got to do. They need to make it transparently clear and measurable.
So in a small-scale redundancy situation, what does meaningful consultation consist of?
Meaningful consultation means genuine dialogue, two-way dialogue between the employer and the employee who may be potentially made redundant. And that includes consultation on the various stages of the redundancy process, from whether there is a redundancy situation, harking back to what I said earlier about diminishing or cessation in requirement for employers to carry out work of a certain kind. Pools for selection, I've also talked about, need to consult there. Selection criteria as well, and then not just the answer or the outcome of the selection criteria, but the provisional outcome. So what they must communicate to the individuals is they have been provisionally selected for redundancy according to the application of this objective criteria on a provisional basis, again subject to consultation. And finally, the last piece in the jigsaw for the redundancy process is there any suitable alternative employment? Now, I said that consultation has to be meaningful. It's not a tick box exercise, and it's not simply one meeting to communicate the outcome. It's much more involved than that. And if it isn't as involved as that, then there is a risk that the employment tribunal will find that there's been an unfair dismissal due to redundancy. So the tribunal may say, well, there is a redundancy situation, but we don't think that the employer has gone around it in the fair and reasonable way.
Thank you, Nick. So we've got our redundancy situation, we've decided who's affected, we've got our pool, we've thought about the selection criteria. You referred to the employer having to consider alternative roles for a redundant employee. Can you talk us through what's expected of an employer in relation to that?
So what that looks like in practice, to be fair, if the employer is going to overcome any challenges in the employment tribunal, is not just simply invite the employee to look at the job vacancy list or the job board, but actually to discuss what sort of suitable alternative employment they would like to consider. And that means discussing their skills and experience and how that is matched in relation to certain roles that may be available. Also, it's about discussing whether if they're a part-time employee, would they consider full-time work? And if they're a full-time employee, would they consider part-time work? And that discussion is important because that's gathering useful information to establish what sort of suitable alternative employment the employer is able to offer or signpost. Again, it's not a box ticking exercise. Also, I'm often asked, well, what happens if we've already given notice to the employee of redundancy and we've triggered their notice period? Are we still obliged to consider them for suitable alternative employment? And the answer to that is very much yes, because if they're expecting to be working their notice period in their existing role, even though that may be redundant, the fact is that they have to be given an opportunity to apply for suitable alternative job roles during their notice period. And that's really important. That's often overlooked by employers. And also, it's important to bear in mind that if there is a suitable alternative position out there, and suitable is by reference to their skills and experience, their status, and their pay and other terms and conditions, then is the employee going to accept that offer of suitable alternative employment? If they don't accept the offer of suitable alternative employment, they may actually lose their right to statutory redundancy pay. So it's pretty important to make sure that the suitable alternative employment bit of the process is handled correctly.
And finally, Nick, what's your best advice for employers handling small-scale redundancies?
I always advise our clients to make sure the process is scrupulously fair, well documented, even if the notes are written down, that they can be retrieved, better still if they're typed up, in relation to every consultation meeting, because you never know, they might be asked questions about a certain meeting. And also keep it human, in the sense that this is a really difficult experience for an employee to go through. And on a human level, they need to be treated with courtesy and dignity, even if they are likely or possibly going to be losing their job due to redundancy. So it's important to have all of those elements in a fair consultation process.
Thank you, Nick. Plenty for employers to think about. If you would like assistance on planning a fair and lawful redundancy process, then please visit our website or contact the employment team at Thompson Stanner Passmore. So finally, thank you to Nick, and thank you for watching.
Thank you for watching.